I'm Drew Stevenson, and this is a video for my professional responsibility class about ABA Model Rule 1.8a, which is about business transactions with clients and conflicts of interest. Now, we're still talking about conflicts of interest, but unlike 1.7, which addresses conflicts between the lawyer's different clients that the lawyer's representing, this one is about the lawyer's personal conflicts of interest or vested interests. And the first category of those, there's going to be several different types of categories on 1.8, is business transactions with clients, which is actually pretty common that lawyers borrow money from a client, lend money to a client, sell something to a client, or buy something from a client, or even accept a property interest from a client in something in lieu of their legal fees. So this video is going to talk about the provisions of the rule. A second video is going to talk about the comments that are likely to appear in test questions on my exam or the MPRE. So let's dive in here. 1.8a says, a lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless, and we're going to have a bunch of exceptions here. 1. The transaction and terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. 2. The client is advised in writing of the desirability of seeking and given a reasonable opportunity to seek the advice of independent legal counsel on the transaction. And 3. The client gives informed consent in a writing signed by the client to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. Now, I want my students to notice that there are 3 writing requirements here. The terms have to be transmitted in writing. The client has to be informed in writing of the desirability of having another lawyer represent them in the matter because you're the other party in it. And the client consents in writing and signs it to the essential terms and the lawyer's role in the transaction. So now these can be attached together in a package or sort of a long multi-page document, but in test questions, make sure that you remember that there are 3 writing requirements in 1.8a for business transactions with clients. I made the slide a little bit intentionally cluttered to highlight for you all the hoops that a lawyer has to go through or boxes they have to check in order to comply with 1.8. If they leave any of these out, they could be subject to discipline in their transaction with the client. And so we're going to go through these 1, 2, and 3 one by one and unpack them a little bit. So first, 1, the transaction and terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. So notice, in a sense, we have multiple requirements just in subsection 1. First, the transaction itself, the terms, has to be fair and reasonable. So if the client is selling you something and for pennies on the dollar, way below market value, then that's probably going to be out of compliance with this rule. Or if you are selling something to the client and gouging them on the price, charging something that's way above market value, that's not fair and reasonable to the client. The same is true if you get an interest-free loan from the client or you lend the money to the client at a really high interest rate. So we're generally talking about fair market value here or appraisal value or some objective way that you can show that this was fair to the client and reasonable. And you have to thoroughly disclose it, and you have to do it in a way that the client can understand. So don't use legal jargon or heretofores and wheretofores, or legal terms that a non-lawyer client can't understand. Obviously, if the client is also a lawyer, then we'll assume that they might understand some of the legal terminology. But if your client's a non-lawyer, the writing that explains the transaction needs to be very clear and in sort of plain English, and avoiding legal jargon. And also keep in mind that it has to be thoroughly explained and disclosed to the client. So no surprises or things that you're keeping from the client. Second, the client is advised in writing of the desirability of seeking independent legal counsel, and is also given a reasonable opportunity to do that on the transaction. And so we're going to have some other rules that require the lawyer to advise the client to maybe talk to another lawyer, or that it would be better for them to be represented by another lawyer in some aspect of what they're doing. But this one actually requires that you put it in writing. So watch for that on test questions. It's not enough to orally advise a client, boy, it would be better if you had a separate lawyer for this. Keep in mind, of course, that sometimes your client already has another lawyer. If you're representing, if the client is a corporation and they have in-house counsel, that's the person with whom you've been dealing, then they already have another lawyer. Sometimes a client has a transactional lawyer and you do their litigation work. And so if they already have independent legal counsel, and that person is going to help them out or advise them on this, then that would satisfy this. Also notice you have to allow sufficient time. And so you can't agree to a business transaction and then tell the client I'm required to advise you to have independent legal representation on the matter, but the deal's off the table at the end of the day or at the end of business tomorrow or something like that. That's not reasonable. If a client has to start from scratch finding a new lawyer, they have to call and make an appointment and then go in for a consultation and see if that lawyer will represent them for the transaction. And so that could take 2 or 3 weeks, and that would be the reasonable amount of time. Third, the client gives informed consent in a writing signed by the client to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. Now notice that the document where the client's consenting to the terms and conditions, that would overlap with 1.8A1, where you were supposed to put in writing the terms and conditions. But notice that here they have to give written consent to the term. So it's not enough that they've just been advised. They have to say, I hereby agree, and so forth. And very importantly, they have to acknowledge what your role is. Clients are often confused about this, about whether you're trying to represent them on a matter, but for this transaction, you're not being their lawyer, or are you purporting to be the other party in the transaction and represent them at the same time. Now, I do want to say something, and I want to make clear for my students, so I'm going to return to this in the next video. We are not talking about your regular fee agreement with your client, how much they have to pay you, whether it's an hourly rate or a flat fee or a contingent fee. All of those are covered under a standalone rule 1.5. But sometimes clients don't have the finances on hand, the cash on hand, to pay their lawyer, or their bank account is empty. And so clients may want to give you property in lieu of legal fees or services, do free accounting work or bookkeeping work or something like that to pay off their legal fees. In that case, you have to satisfy both the rules about legal fees under 1.5 and it's a business transaction with the client. Sometimes clients sign over an ownership share of their business or some real estate to the lawyer in lieu of fees. You have to satisfy the fee requirement rule and the requirements of that rule, and the requirements of 1.8A, because it is simultaneously payment of fees for legal services, and a business transaction with a client. And that concludes my introductory video. We're going to have a second video where we go through the comments that are relevant for test questions.